And we did briefly discuss the functions of a tracer, and that there are certain tracing agents that really do a good job, and they normally do their tracing on a no trace, no fee basis. So we try and trace the data, and most of our clients would ask us to do 2 to 3 trace reports from different tracing agents. And if we do not manage to successfully arrest the debtor, then they would ask us to close the file regardless of the quantum. Now, just remember, at this stage, you already obtained judgment in your earlier um, process that you followed. So it's happened many times that a debtor at some stage wants to go to a financial institution, apply for credit, and then they cannot obtain the credit because the judgment will reflect against their name, and then they will give your office a call. That will then be a good opportunity to enter into some settlement negotiations or to try and get some money in, even after your file has been closed. Another question that we received was in relation to the emoluments attachment order. You will recall when we discussed this, I mentioned that this is the deduction of a certain amount against the debtor or employee's salary to be paid over to the attorney's trust account. Now, the question we received related to what the process would be if a debtor, a couple of months after service of the emoluments attachment order, the specific debtor just suddenly absconds. So what we do in practice, obviously, your uh, employer will then no longer make payment on this file. You will phone the employer, and the HR department will most probably say, but this person is no longer in our employ. What we then do is we obviously need to trace the debtor. We've already got a judgment, you'll remember. We'll trace this debtor, and then when we do find the debtor and we do find his next place of employment, then you will have to transfer the the file from the magistrate's court to the magistrate's court where the debtor is currently residing. If he is in a different jurisdiction, if memory serves, this is section 65J. I might be talking under correction though. And then what we will do then is we'll just reissue the emoluments attachment order in that new jurisdiction, and the sheriff will then proceed to serve same upon the next employment, and that company, however, will then need to make payment of the specific amount. We also discussed some of the processes to follow when debt collection becomes opposed, and we mentioned that it might even become opposed during what we call a rescission of judgment application, where your debtor receives the warrant of execution by the sheriff, and he says to the court that this is the first that he's hearing of this matter, and he brings an application for rescission. You will recall that we mentioned that the application for rescission must be launched by the debtor at least 20 days, 20 court days from the date of becoming aware of the judgment granted against him. So opposed debt collection will, in essence, continue all the way to trial, where you will examination in chief, cross-examination and re-examination of witnesses will take place, and your magistrate and or judge will make a decision. And that decision, if you receive a successful judgment at trial, your next step will be to continue with your writ of execution. We briefly touched on the process to follow when the matter does become opposed, with the filing of a plea and or maybe even a counterclaim, and then all the way to trial through pre-trials, discovery, consultation with witnesses, etc. Lead does, however, have another course, a civil litigation course, where this process that I briefly touched on now for 2 minutes will be discussed in much more detail. We also received a question relating to costs. Just shortly, relating to the costs issue, we mentioned during Monday that costs that we see on our summons and default judgment and so on is normally the cost that we would find in the magistrates court cost scales. And the question we received related to how do we actually bill our client and what do we need to bill our client. Again, this is also a specific course that will be lectured by Lead. There is a cost course. So if you feel like you want to get more information, you can just email Merlin in relation to that. One of the most important aspects that we also touched on during Monday was the aspect of jurisdiction. And I think I just quickly want to pause here. When we deal with jurisdiction, just again for revision purposes, we mainly have two forms of jurisdiction. Firstly, the monetary jurisdiction, and then secondly, geographical jurisdiction. The monetary jurisdiction of the different courts that we have in the magistrates court is 0 to 200,000 for the district court and 200 to 400,000 for the regional court. Any matter with a claim amount in excess of 400,000 will need to be issued from the relevant high court. We mentioned that you might have a claim that is just over the specific amount of 400,000, and then you may advise your client to abandon a portion of that claim in terms of Rule 38 to bring this matter within the jurisdiction of the magistrates court. The reason for this will be to save on time, costs and time. The geographical jurisdiction, we mentioned that you might have one regional court that will hear matters pertaining to several district courts. So your smaller court being your district court and your bigger brother being the regional court. Make sure, just as a side note, and I did mention this on Monday, make sure that you do issue your summons from the correct court. Alternatively, if you do not do so, you will most probably receive a special plea against yourself and or the attorney. I then want to move on to some of the other questions that we received on Monday before we continue with the topics for today. And a specific one that we received reads as follows. Under which rule does it say that a summons lapse after 1 year? This was from a Mr. Skalk Albertine, and it says that Rule 10 was abolished. That is 100% correct. I had a look at this rule, and this was something that I needed to address today just to rectify this. The Rule 10 of the Magistrates Court rules was abolished, and your summons will no longer lapse after 1 year. So thank you for the correction there, Skalk. Another question that we received is if the employer does not react to the emoluments attachment order served on them, what steps can now be taken? And this regularly happens where the employer does not make payment of the amount as per the court order. And what we've done successfully is to threaten the employer with a contempt of court application. And then normally what they do then is to make payment. So your step there will be to continue with an application to court, a contempt of court order application. We won't go into detail because we do have a number of other things to discuss, but that will be your step. Another question that I'd quickly like to discuss is the following. What happens when you cannot trace the debtor in a Section 65 situation, even with tracing agent aid and deed searches? Is there an alternative route? So remember, the route that we are following is an unopposed route because our debtor never filed his notice to defend. So the only route that you can follow is to try and trace this person. You must remember that there's two other concepts that we must discuss here. First one being what we call edictal citation, and the second one that we call substituted service. So the difference between the two concepts is as follows, and both has got to do with the service of documents upon another party. The main difference between the two is as follows. Edictal citation is when you bring an application to court to serve papers upon a person that is not within the Republic of South Africa. Edictal citation is through court application, and there's a whole procedure to follow. When it comes to not edictal citation, substituted service, you launch a court application where you ask the court to provide you with a directive, and the court will provide you with a directive as to how to serve documents upon a party when this party is within the Republic, but you are not sure exactly where. This we normally see when we deal with divorce matters, where parties have separated but never divorced, and years later one of the parties want to get divorced but do not know where the other party resides anymore. Then we will make use of this application for substituted service. Your problem, and with your question, is the following. It says, what happens when you cannot trace the debtor in a Section 65 situation? Problem with the Section 65 situation is that your debtor will need to appear in court, and your debtor needs to answer in terms of his financial capabilities and the position that he finds himself in. So an application for either edictal citation or substituted service will not assist, because you will need to get your debtor there personally. So like I mentioned, what some of our clients would do is to try and trace 1, 2, maybe 3 times. If unsuccessful, then we close our file, because we do have judgment granted, and judgment will only prescribe after 30 years if you have your default judgment granted. A question that we received: can an employer refuse to grant the emoluments attachment order? Now, I think that the wording is not correct here, because the employer does not grant the emoluments attachment order. It is the specific court that will grant the EAO. When the court grants the emoluments attachment order, the sheriff merely serves it upon the employer. The employer then must pay the funds as per the court order over to the attorney's trust account and will not be able to refuse. Alternatively, you continue with your application to court, your contempt of court application. Another question, if attachment has lapsed on a warrant of execution, what are the options? So it depends, and this will depend from matter to matter. Remember, I mentioned on Monday, your warrant of execution for movable property will lapse after 4 months, and for immovable property, it will lapse after 1 year. So let's say you attached and you managed to attach a decent amount of property, but never arranged a sale, or your debtor made certain payments. What do we do now if the debtor suddenly defaults again and we need to continue, but the attachment lapsed? Unfortunately, you will need to reissue your writ of execution and then go and reserve. If your attachment has lapsed, you will not be able to continue with the sale and execution. Remember, we mentioned that you need to also advertise your sale and execution if the goods attached is of a value, an estimated value more than 5,000 rands, and that your advertisement should be in the local newspaper. Question that we received: what happens if a debtor relocates from the domicilium address and you cannot trace the debtor? So this specific situation we use on a daily basis in our firm, because we do quite a lot of levy collections, and you must remember that the levies is applicable upon a certain property within a scheme, and that property will be seen as a domicilium for purposes of the levies. Now, if the debtor doesn't stay there, or a tenant stays there, or a debtor moves, what we like to do in practice is to always serve upon the domicilium and then to obtain judgment, because you should be able to obtain judgment quite easily. But when you continue with your writ of execution, you will obviously not be able to serve on the specific property where you served your summons, because the debtor has moved. So what we then do is we trace the debtor in his personal capacity and attempt to serve the writ of execution in such a way. Please also just make sure, if you deal with debt collection based on a contract, for instance, a lease agreement or a purchase agreement, or maybe even a credit agreement with one of the banks, these contracts are normally well drafted and should have a domicilium clause in there. It doesn't matter whether the debtor does reside there or not. You merely wish to, at this stage, obtain judgment. So you would have started with your soft collections, found the debtor, um, uh, placed pressure upon this debtor, and the debtor did not make payment. If you need to continue with litigation, I think one of your safest bets will be to serve your summons or legal process, whatever process you follow, upon a domicilium address. Obtain your judgment, because your judgment will only lapse after 30 years, or prescribe rather after 30 years, and then proceed to trace the debtors in their personal capacities. We see this quite regularly with the banks, where the debtor entered into a loan agreement, for instance, and a couple of years later starts to default, but the address that the bank has as a domicilium is not the address where the debtor is currently residing anymore. Use that old address in the meantime to at least obtain the judgment. This is a very important question, and something that we didn't discuss during Monday. If a plaintiff has more than one claim against the defendant, for example, it's 3 loans given to the defendant on 3 different dates, should all claims be in different summonses or added together and claimed in one summons? So the short answer to this is 3 different claims on 3 different dates will mean 3, or should mean 3 different causes of action. A debtor might go to a financial institution and he owes the financial institution pertaining to an agreement, a credit agreement for the purchase of a vehicle, and maybe a personal loan, credit card, or a bond. So it's 3 different causes of action, and you will see a little bit later on when we discuss the National Credit Act and some of those clauses, or sections rather, that there is a specific duty on the financial institution to do their own due diligence when affording credit to their clients. So 3 different causes of action, that will be 3 different summons. Another question we received, if an original warrant of execution goes missing, and this happens daily, how do you go about getting another? So a sheriff will not be able to serve a warrant of execution if he doesn't have the original. You will recall, for those of you that attend to the sheriff's offices, they normally want the original plus 1 copy. The reason for this is because they need to show the original to the debtor. They need to provide the debtor with the copy, and then when you receive your return of service from the sheriff, you receive your original back. The problem, however, is that some of these documents go missing, and how do you go about obtaining a new original? So firstly, you'll need to redraft your warrant of execution, and you will need to go to court. The clerk of the court will need to draw the file and then reissue the warrant of execution, a new original for you. It's quite a simple process, and I know in the High Court, especially in Pretoria High Court, when you enter into court, there's a small office on your right hand side where they'll also check on the system at the High Court whether judgments were granted in that specific matter, and they will reissue your warrant of executions as well. Normally, they request a lost document affidavit from your office, wherein you will then just explain the background. Then another important question I received, the last one before we continue with our other topics, relates to the fact that if we issued summons for 500 rands and we received payment of 250 rands, and we want to apply for judgment, for which amount do we now apply for judgment? For the full 500 or for the 250? So the short answer to this is you only apply for judgment what is still due. The reason for this is if you go and apply for judgment at court for the full 500 rands, then that will be grounds for rescission of the judgment. Should the debtor see later that you obtain judgment for the full claim amount and not just for the portion that was still owed. So when you apply for your judgment, you will say for the capital amount of 500 less payment received 250, maybe with a date as well, and that equals 250 rands that you will ask judgment for, plus costs and the costs and interest as well. All right, so let's move on to a specific topic, and I think a lot of you might have heard this, especially now during the lockdown period, and it's called the vis major remedy. Now, the vis major remedy is one that's very prevalent in these times, and basically boils down to the fact that your debtor says that he's in such a position where it has become impossible for him as a debtor to make payment of the contractual obligation. So let's explain this by making use of an example such as the property market, and let's focus firstly on commercial properties. So if you have a client that's a commercial landlord and you do a lot of debt collection for them, you might have been asked a question, but what is the stance relating to vis major? So in short, you must have a look at each and every case in their own merit. So you will recall during level 5 lockdown, the regulations made it very clear that only certain shops and banks were operational, such as your grocery outlets, your pharmacies. If you have a look at a normal shopping mall, your grocery outlets, pharmacies, banks, etc. Most of the others were closed, 100% closed, which means that according to legislation promulgated by the president, those shops could not legally trade. That means that they were in a position where it became impossible for them to perform in terms of the contract. So let's say my client, the landlord, instructed me to say, Gerald, this tenant has not made payment for April, May, June. Then questions that I'll ask my client is, were there any emails back and forth relating to vis major or the restructuring of the debt? I know that a lot of the landlords went to their tenants and they negotiated what we would call a TI, or a turnover income, where they only pay over a certain percentage of what their turnover was. Now, remember, the vis major remedy basically means that it was completely impossible to perform in terms of the contract. So if that specific tenant was already in arrears for 6 months before lockdown, then he cannot rely on this because he's already in breach of the lease agreement. And then secondly, if this tenant could partially operate, and we saw this in, I think it was level 4 and level 3 lockdown, where some of the tenants could start producing takeaway meals, and so they could operate, but only to a certain extent. then the vis major rule will no longer exist, because it's not impossible for them to perform, although much more difficult for them to perform. So I think that the main word to be used there is impossibility. If we move the concept of vis major to a different industry, which we will also discuss, such as the levies, then the fact of the matter that someone might have become retrenched will not qualify that person to make use of what we call vis major. So what a lot of the corporate entities did that specifically deal with the collection of levies is that they went to the body corporates or homeowners associations, had a discussion with the board, and they passed resolutions to state that they will take hands with some of the owners and just divert some of the payments. But again, if the owner was in arrears for a couple of months of levies, then they were already in breach and will not be able to claim the remedy of vis major. If you have any questions on this, please feel free to send me your questions, and I'll try and discuss this as well as we continue. Another form of debt collection. I spoke to someone specifically yesterday at the Pretoria High Court. We had an urgent application yesterday at court, and when I had a discussion with a specific person, the person told me that she is a cost consultant. So a cost consultant, for those of you that don't know what they do, is that they would continue to draft specific bills after a matter was heard in court, and then they would go to the taxing master, set the matter down, get the bill taxed, and that taxed amount will then be collected by these taxing attorneys or cost consulting attorneys. And what this lady told me, that what she does is that she goes to urgent court, and the reason being, urgent court normally has matters that where they use advocates. So that means that the legal cost bill will probably be in excess of 50 to 80 to 100,000 rands plus. And then what they do is they make a note of all the matters that will be heard and who the attorneys will be. They send them mails afterwards and ask them whether they can tax those bills. That's obviously a nice form of them getting work in, and then also continuing with the collection of the legal costs. So if a legal cost bill was taxed by the taxing master, that bill has the same effect as a court order, and you will continue with a writ of execution against your opponent to get your costs in. Yesterday at court, when we attended to the urgent application, just to give you an idea, the court had 33 urgent applications set down. So you can just imagine the amount of money that will need to be taxed and collected. I would like to continue to have a discussion about the property market and evictions specifically. Now, in theory, we have three forms of evictions. The first form of evictions will be commercial, and we all know what a commercial company is. And then secondly, residential houses. And then thirdly is what we call ESTA evictions, and this is evictions in relation to farmland. Now, just shortly in relation to ESTA evictions, we have the Land Claims Court in Randburg, and we launch our applications for eviction there, but that doesn't really have anything to do with the purpose of our course. So I want to move to residential evictions. So if you do collections for your typical Remax or Seif properties, or any property company dealing with residential properties, they will phone you up and say, we've got 20 people that's default, which owes for arrear rentals. Your advice to the client will be to obviously always continue, firstly with a letter of demand, and then to issue summons for the arrear rental. But the fact that you do issue summons does not necessarily cure your problem that you're dealing with, because that tenant might just continue with the breach and might just sit at this property, refusing to vacate the property. So the only way to get the tenant away from this property is with an eviction order. So you need to launch an application at court, application for eviction. In terms of you might have heard this act, the PI Act, the Prevention of Illegal Evictions Act, and especially Section 4, subsection 2 of the Act. And then what we do in practice is to do two things. Number one, to issue our application for eviction, and then secondly, when we do get our court order, to also send the sheriff to attach the goods of the specific person in order to claim our monetary amount. So there's two main things that we ask for from court. Number one is for the collection of our arrear amounts, which you will set out in your founding affidavit. And then secondly, we ask court to grant an eviction order. This eviction order is an order that will be executed by the sheriff of the court. And in actual fact, what happens here is the sheriff will get into their cars, go to this property, and if there is something that is worth of value, to attach that and remove to storage to be sold in order to regain the losses incurred by the owner, or to regain the amount as per the court order, and to secondly to evict. So what we do with our clients is that we ask our client, the owner, to also be at the property to move something or someone into this property and to change the locks, because it has happened regularly in practice that you evict and then the sheriff leaves and that ex-tenant just moves back into the property. You need to execute the eviction again. The costs involved, sheriff's costs to do the eviction, is on a case-by-case basis, and it is quite expensive depending on the size of the property or whether the sheriff needs to get public order policing in or the SAPS in. So it's on a case-by-case basis. On a side note, you may also continue to ask for eviction in a normal combined summons. We've done so with success, wherein we ask the court to grant, based on action procedure, not just an order for the arrear rental, but also for eviction, and then that court order will then be executed by the sheriff. When we do, however, go to commercial properties, and we talk about commercial properties, the court will hear the application for eviction, and there's not a lot of boxes to tick to get your eviction order, because when it relates to residential property, there is certain requirements in terms of the PI Act that you need to meet in order to get your court order. But when you specifically relate to your residential or commercial properties, the court will ask whether there's a contractual relationship between the two parties, whether there's been breach of this contractual relationship, whether the tenant was placed in breach or in mora in terms of a letter of demand, whether the contract was cancelled, and then thereafter grant you your eviction order. What we normally do with some of our larger transactions, where our property owners, normally big corporate companies, where they say, give us instructions to continue with an eviction of a corporate company, is that we will not just continue to evict and throw them out of the premises, but the property that's within the corporate premises might be of much more value than what you would find in a residential property. So you must remember that your client is the owner of the corporate property. Chances are that they do not have a tenant waiting to take occupation of the specific premises. So what we do then is to instruct the sheriff to evict everyone, evict all the people, and to leave all the property within the premises, to attach everything in terms of a writ of execution, to draft an inventory, and to supply our office with a date for the sale of the property. This saves a lot on costs, where the sheriff will then just not charge us any storage costs because the sheriff didn't need to remove. To give you an example of costs, we recently continued with a specific matter in the Randburg area, where the sheriff was instructed to go and attach and remove property at a very, very big corporate corporate business. And the sheriff charged us for 3 or 4 truckloads of furniture to be removed, almost 40,000 rands in sheriff's fees. The property is now in storage and we have a date for sale. But the problem that we do have now is that we need to pay for the removal fees, which is the 40,000 rand, and the sheriff will also charge us for the storage fees. So we need to make sure that the property that's actually attached and removed is worth having the sale. Because if you do not manage to sell for more than you spent, then you're going to have to pay in by the sheriff's office. If you have any questions relating to evictions and the collection of the rear rental, you can also just pose the questions. Something that's also very important there is that we always advise our corporate clients, especially with corporate evictions, to make sure that they have some form of security built into the lease agreements. Security in terms of deposits, 3 to 6 months worth of deposits, or to have someone sign personal surety. It happens very often that a company, especially now with COVID, where companies will start going under business rescue. I think that's something that will be prevalent in the coming months. And also companies going under voluntary liquidation. I think there will be a lot of those coming in the next months, where you then ask your client, your corporate client, to have personal surety. So should the company go into liquidation or business rescue, at least you may continue to issue summons and push for the outstanding amount against the surety. So if we now continue and discuss levies, I just want to touch on this, and the reason why I keep on going back to levies is due to the fact that in today's day and age, I don't see a lot of areas being built that's not enclosed. So most of the developers will build closed off areas, which means you're going to deal with a sectional title or a homeowners association. You may go and read those 2 sections. It is very lengthy though. The Sectional Titles Act, very important to be used when collecting rear levies. So what will happen here is that your specific sectional title will be governed in terms of the Act. There will be a memorandum of incorporation. There will be a board of trustees, and they will run the operations of that specific block. Now, they then give instructions to managing agents, who will then in turn instruct attorneys on a specific cost scale to collect arrear levies. You can just imagine if you sit with a complex that has 1,000 or 2,000 units, and you only have 5% of these owners that default. If you have 5% in 1,000 units, that's 50 cases of arrears that needs to be collected. And to be honest with you, 5%, I think it's very conservative. So collection of levies is very prevalent in today's day and age, and we do that in terms of the Sectional Titles Act. Right. Before we continue, I just think we'll take a 2-minute break, and then we'll just continue with the discussion on levies. All right, welcome back everyone. We just had some technical difficulties to try and sort out. If there's anyone that's having any issues, kindly just call Millen or send her a mail and we can quickly try and sort that out. I think in the meantime, let's continue with the discussion on the levies. I still mentioned that we need to continue with our action procedure to collect levies. And what is very important that I think we need to be sure of is to make sure that what we ask at court we may actually receive, because these are some of the queries that we've seen from court lately regarding default judgment. So make sure that when you read your memorandum of incorporation and you deal with the specific collection of levies, that your memorandum of incorporation specifically mention which costs may be included on the statement of the debtor, because the costs that's included on the specific statement of the debtor must be costs that will go to the sectional title or the homeowners association. So the memorandum of incorporation must state that if there is interest, what the interest amount will be, and if there is collection commission, what the collection commission will be. Otherwise, the court will have a lot of queries on your default judgment. But as soon as you have default judgment granted, then the process is exactly the same, wherein you would continue with your writ of execution, your Section 65 procedure, etc. With the collection of levies, it happens more often than not that you continue with your collection, and when you reach the stage of a writ of execution, you receive a return from the service, specifically stating that the owner does not reside within the premises, but rather a tenant. Now, this goes hand in hand with the discussion that we had on Monday, and we normally give the sheriff strict instructions to continue with the attachment of the property, although it is a tenant that stays there, because that tenant should continue with the interpleader proceedings that we discussed on Monday. Another portion, just quickly a minute on this, is if you continue with your collections of levies and you have an amount that is sufficient in terms of launching an application in terms of Rule 46 in the High Court to attach immovable property, then you may also continue with this to sell the immovable property. You will be surprised to find that many times some of these clients owes levies in the amount of 2, 3, 400,000 rands and have just not made payment of the levies for many years, but no legal action was taken against them. If you can manage to get your court order for the specific amount and in terms of a default judgment or otherwise, then you may continue with an application to court. And we briefly touched on this on Monday to say that when you bring this application, you have certain documents that you need to attach in order to be successful with this application to sell the immovable property in order to recover the levies. It must, however, be noted that a magistrate or judge will not grant this order if the amount that you seek is, let's say, 30, 40, 50,000 rands. A magistrate or judge will not easily grant this if this is the primary residence of the specific debtor, due to the fact that such a small amount might be sorted out at a Section 65 court rather than an application to sell immovable property. We've been successful with these in the past, where we then continue all the way to Section 65, and then let's use an example where the debtor is unemployed and the debt is just increasing and there's just no money to be deducted from a salary. Then we would go back and launch an application and in our founding affidavit, explain the background to the magistrate or judge and say to the magistrate that we would not be successful with the Section 65, although the amount does not necessarily warrant the sale of a property that's, let's call it, over R1 million in order to get a 50,000 rands debt in. and then we would get our orders granted. One specific aspect that I would like to continue to discuss is the amendment of pleadings. Due to the fact that you'll deal with debt collection and many pleadings on a daily basis, it regularly happens that you make a mistake with your pleadings. We all know that the difference between 10,000 rands and 100,000 rands is only 1 0. Although it's a very small mistake, it might have severe consequences in your specific matter that you're dealing with. So if you want to amend any pleadings, we will make use of Rule 55. If you have a matter that is opposed, you will draft a Rule 55 capital A, and you will send this Rule 55A to your opponent, and you will, in this notice, explain to the opponent what you intend to amend. What will then happen is that your opponent will have 10 days to oppose your Rule 55 capital A, and if they do not do so, you will file a Rule 55A7 with the amended papers rectifying the mistake that you made. Normally, in practice, to do these amendments are not so difficult, and they mostly are not opposed. And the only reason I would think of to oppose a Rule 55 is if the party that intends to bring an amendment suddenly wants to amend several portions of the litigation, and then basically use a specific remedy which they didn't plea at some stage, or to change the course in which the matter has been traveling on. So normally, if it's just for a bona fide mistake, then these amendments may be effected with a Rule 55. Right, before we continue with the National Credit Act, which is quite a lot that I want to discuss, we received a few questions, and I quickly just want to run through them. The first question was, do you first need to send a notification to the employer before applying for the emoluments attachment order? The answer to this is no. So when you appear in your Section 65 court, you will ask the court, you'll say, Your Worship, we are happy with payment in the amount of 5,000 rands per month if the matter was settled before, and then you will ask the court to grant the emoluments attachment order. The court will then grant it, so you don't need to ask the employer's permission or just notify them that you will be applying for the emoluments attachment order. The first that the employer will see of this document is when it is served by the sheriff upon the employer, instructing them to make the specific payment. So no notification needed. Another question regarding the vis major discussion we had. What about vis major with regard to payment holiday on a home loan, and now client cannot pay due to loss of income or retrenchment? Now, many financial institutions assisted their clients with a payment holiday of a 3 or 4, 5 month payment holiday in terms of their loans. The fact of the matter is that that specific debtor entered into a contract, and at the date of signature of the contract, this debtor was in the financial space to make payment of his obligations. Now, the financial institutions assisted with a payment holiday, and some of them did this in different ways. The payment holiday mostly related to the debtor not needing to pay for the 3-4 months, but that specific funds will then be distributed over, let's say, another 12 to 24 month period. The fact that the debtor then has less income or becomes retrenched does not in effect mean that the debtor can now rely on vis major. Now, you must remember that debtors or the people in general will be retrenched throughout the year. It's not just in relation to COVID-19. So the fact that you receive less income does mean that you do have income, and you will rather than inform this debtor not to rely on vis major, but to rather continue, if they're over indebted now, to continue with an application to go under debt review. Another question we received is, can vis major be applicable if lockdown is seen as an act of God, or as an act of state and not of God? Look, vis major will be used, especially now with the lockdown, due to the fact that the lockdown is regulated by legislation and regulations. So vis major will definitely be applicable due to lockdown, but you must make sure that should your debtor use vis major, that he is in a specific space to do so. So each and every matter will be determined by its own facts, whether the debtor will be able to use vis major successfully or not. Another question was on the taxation of bills of costs, which we discussed. And the question is, can you collect on a taxed bill before the main action or application is finalized? So it happens very regularly, and this is a good question. It happens very regularly that you continue with your litigation and you receive an interlocutory application, some side application, let's say a rescission application, that needs to be heard. And with every application that needs to be heard, there will obviously always be a winner and a loser, and the cost normally goes with the losing party. If you manage to tax that bill, that taxed bill is an order. Even if the main action or application is still pending and there hasn't been an outcome of the main matter, then you may continue with the collection of that specific taxed bill, whether the litigation has been finalized or not. It does, however, happen very regularly that you continue with interlocutory applications or any such application pending the main matter, where the court will reserve costs and the argument of costs to the end of the matter. So it doesn't happen too often that you would get a cost order pending the finalization of the main matter. A question we received, kindly clarify which costs are payable by the client and costs payable by the debtor, that is legal fees, disbursements, commission, sheriff fees, etc. Now remember, when you go to court, you're going to ask court for a few things. Number one, a specific amount that was owed, the capital amount. You're going to ask court for interest, depending on the prime rate or if it's governed by a specific contract. You're going to ask the court for costs. Now, the costs that you ask court might be in terms of a specific cost scale, or party and party costs, or attorney and own client costs. So depending on the costs that you ask, that will depend on the specific amounts you may ask whilst taxing the bill. So just to read the question again, kindly clarify which costs are payable by the client and costs payable by the debtor. So if your client paid you a total amount of 50,000 rands in legal fees for a specific matter, but you only managed to tax 35,000 rands after winning the case, then you will only be able to reclaim from the debtor the 35,000 rands, because you only have a court order for that. A question here that we have, The last one before we move on to the National Credit Act is what happens when someone signs surety and we're in a 24-month contract and we're in the business of selling liquor. We know that this business was also severely hampered by the lockdown regulations and also could not trade, which means that some of your liquor outlets will be able to rely on the remedy of vis major. But the remaining portion of the question, then the said person terminated the agreement during lockdown, and the landlord is of the opinion that she can't terminate because the CPA does not make provision for early termination of commercial contracts. So commercial contracts may be terminated. There may be clauses in your commercial contract allowing you to terminate, especially by the breach clause. The breach clause normally has cancellation clauses as well. But if you have a surety that's signed, then the surety might be held liable for a few things. If there's an arrear amount, obviously for that. And if there is performance that still needs to take place, then you can also bring an application or action rather to force the surety to comply with the contractual obligation. But in relation to commercial contracts, you may cancel a commercial contract, especially if one has regard to the breach clauses of those contracts. All right, I want to move on. I want to discuss the National Credit Act now, and I then want to take a few minutes and then also discuss some questions. There might be some more questions that came in. So in terms of the National Credit Act, I'm going to have a broad discussion and then we'll scroll through the attachment that you see now. The Consumer Protection Act came into operation during 2005 and 2007, so it's been with us for a good number of years. The problems that we do have in practice with the Consumer Protection Act is that it is very difficult to ascertain which matters will classify as a credit agreement, and then if those matters classify as a credit agreement, then we need to make use of the National Credit Act. And many attorneys do not know how to make use of the National Credit Act, in especially the letter of demand and the summons. So let's talk about the litigation portion first. When you continue with your National Credit Act letter of demand, you might know that this is called a Section 129 letter of demand. You will see that there is in fine print on this letter of demand a specific portion, normally 2, 3, 4 paragraphs long, that we copy and paste from letter of demand to letter of demand. Take time and read what this specifically says, and you will note that this fine print informs the debtor that this specific matter is regulated by the National Credit Act, and should this debtor be over-indebted or received reckless credit, then this debtor is directed to a debt counselor or the ONBID or any other remedy in terms of the Act in order to assist the debtor. So the letter of demand basically informs the debtor of his or her rights to a certain extent. So you need to comply in terms of Section 129 of the Act. And if you do not do this and you only write a normal letter of demand and continue to issue summons, when you ask for your default judgment, the magistrate or judge will have a query and ask why you did not comply with the National Credit Act. And even though the merit of your case will be 100%, the procedure followed by the office was incorrect, and you will not be able to have your judgment granted. The adverse effects of this will be time and money wastage, and the problem with the time wastage is that you'll have to withdraw that summons, tender the wasted costs, and reissue, starting with a properly drafted Section 129 letter of demand, and that might lead to your matter being prescribed. So please make sure when you start your process to use the correct letter of demand. But when we move on to the summons, compliance with the summons in the following, in your particulars of claim, you will state to the court that you complied with the National Credit Act, and you may even in your particulars of claim inform the court in terms of which sections of the National Credit Act you complied with. And then even though your matter does not need to comply with a National Credit Act, then you need to say in your particulars of claim that this specific matter is not governed by the National Credit Act, as it does not constitute a credit agreement in terms of Section 8 and Section 9 of the National Credit Act. So you need to have something in your summons, in your particulars of claim, to say that it's not necessary to comply or that you did comply. All right, let's continue. Let's have a look at Section 8 and Section 9. You will see when you read these first 2 to 3 pages, the first 2 to 3 pages is basically just an introduction, and it just tells you what the effect of the National Credit Act is, and it explains to us what how the act is applied, and what is a consumer, and what is a credit provider. You will see here the definition of a consumer with all these bullet points. This you can go and have a read. Credit provider, what is the definition of a credit provider? Then I want us to continue with this section in terms of Section 4 of the National Credit Act, and subject to Section 5 and 6. The National Credit Act applies to every credit agreement between parties dealing at arm's length and made within and having effect within the Republic. So it's only matters that is within the Republic. So you can have a look, except for the following. These will not constitute National Credit Act agreements. So a credit agreement in terms of which the consumer is a juristic person, whose asset value or annual turnover equals or exceed the threshold, presently 1 million, the state or an organ of state. And it continues in Section 5 and Section 6, deal with the limited application of the Act to incidental credit agreements, as well as to cases in which the consumer is a juristic person. For our purposes, I've already mentioned Section 8 and Section 9, and I want us to have a look on page 4 of this handout. What is Section 8 and Section 9? So Section 8 and 9 says, of the Act sets out the classification and categories of a credit agreement. So a credit agreement may be the following in terms of these bullet points. It may be a credit facility, it may be a credit agreement as described, or a credit guarantee, or a combination. So each one of the top 3 bullet points that I'm showing you now has their own specific definition. So you need to know what is a credit facility, what is constituted as a credit agreement and a credit guarantee. And if your matter is any one of those or a combination, then you must make use of the National Credit Act. Policies of insurance, the lease of immovable property. We've spoken a lot about evictions of residential and commercial. When you continue in that space, and you collect residential or commercial arrears, you will not make use of a Section 129 letter of demand. When we spoke a lot about levies so far, you will not make use of the National Credit Act when dealing with the collection of levies. Policies of insurance, lease of immovable properties, and transactions between the members of a stokvel will not be governed by the National Credit Act. So just again, you must have a look at what is a credit facility, what is a credit agreement as described, and what is a credit guarantee. And if your matter falls within those definitions, then you make use of the National Credit Act. I want us to continue, scroll down. Here is an agreement constitutes a credit transaction. if it is the following: a pawn transaction, an incidental credit agreement, installment agreement. This is typically your vehicles, credit cards, etc. A mortgage agreement that you pay off monthly. Then you will make use of the National Credit Act, or any other agreement other than a credit facility or credit guarantee in terms of which payment of an amount owed by one person to another is deferred. This is important. So if you go and you buy on credit, chances are that you will be charged a fee or interest if you do not pay. If you've got a 30-day, 60, 90-day account with a company, then you will need to collect in terms of the National Credit Act. But let's just read through this again. Any agreement other than a credit facility or credit guarantee in terms of which payment of an amount owed by one person to another is deferred, which means you pay off monthly, and any charge, fee, or interest is payable to the credit provider in respect of the agreement. So there is litigation um, uh, specifically pertaining to this, where certain companies would say that you have a credit facility with our company to the amount of, let's say, 100,000 rands. But what what the company did not do is that they didn't charge any fees or interest. So they would say that we do not charge fees or interest within the first 60 days or 90 or 120 days. We'll only thereafter start charging fees or interest. So they will say that we do not need to comply with the National Credit Act due to the fact that we do not charge any fee or interest. That is 100% correct. They do not need to comply with the Credit Act. But because it is a credit facility, it falls within the definition of one of the other bullet points, which means they still need to comply with the National Credit Act. Categories of credit agreements, you will see in terms of section 9, there is what we call small, intermediate, and large credit agreements. I'm not going to delve into this. I think you can go and read this yourself. I need to get to other portions of the National Credit Act. There's certain credit agreements subject to less stringent regulations. You can also go and read through this. I need to stop and discuss this over-indebtedness and reckless credit. You will see there's a heading there in bold in terms of section 79. And now we will be dealing with certain sections in terms of the Act 79, 81, 82, 83, 86, etc. And this portion from here on further specifically deals with financial institutions providing credit and your specific consumer going under debt review. So let's just discuss debt reviews before we look at the specific sections. So a debt review is where a specific debtor sees that he is over indebted, or he received reckless credit from a specific financial institution, and due to that fact became over indebted and cannot satisfy his or her financial obligations. Such a person will then go and see what we call a debt counselor. Most of you would have heard of a debt counselor. The job of the debt counselor is to do the following, is to do an assessment and to make sure that the specific person is over indebted and or whether the specific person received reckless credit. The debt counselor then needs to do the following. He needs to make a recommendation. The recommendation to court will be to either go under debt review or to declare a specific transaction received by this debtor as reckless credit. The implications, should the debtor have received the reckless credit, is that the court may be asked that the reckless credit be set aside, and the effect thereof will be that the financial institution will not be able to collect that reckless credit. But in essence, what happens with most debt reviews is that the debt counselor will assist with the drafting of this debt review application, and there's a lot of firms that specialize in debt counseling. and debt reviews and administration thereof. But they will draft this application in terms of Section 86, and we'll have a look at Section 86 just now. And the main aim of the debt counselor is to reduce the monthly expenses of the specific debtor. This will have adverse effects, such just as a sequestration would have, in that the specific person that's going under debt review will not or should not be able to act as a director of a company or to obtain any further credit for the duration of the debt review. Two things happen in this specific application. Number one, the debt counselor will restructure the debt in terms of, number one, the time frame. If the debtor had a personal loan, for instance, and had 2 years left on the loan, the debt counselor will be in contact with the financial institution and request them to prolong that time frame to 3 or 4 years, which means that the monthly installment will be less. Secondly, the debt counselor is also supposed to request that the debt be paid at a more favorable interest rate. This will also have the effect of the specific monthly amount being lowered. The debt counselor will then see that this specific debtor has 10 accounts that he needs to pay every month. He or she needs to contact all 10 of them and restructure the debt with all 10 of these specific accounts and attach the necessary proof of this to the application at court. This will have the effect that your debt counselor will also say what the duration of the debt counseling will be. A couple of years. Normally people go on a debt counseling for 5, 6, 7 years. But I've also heard horror stories where specific debtors are under debt counseling for 20, 25 years. And I cannot see how that will be in the best interest of the debtor. Must always remember that your debt counselor must act within the best interest of the debtor as well. And if the debt counselor sees that there is reckless credit that was obtained, the debt counselor is supposed to inform the court accordingly. And if not, the debt counselor, or the court rather, may request that an additional debt counselor's opinion also be obtained. In practice, then, what happens is that the Section 86 application will appear in court. If the magistrate is satisfied with the process that was followed, the magistrate will grant an order stating that the debtor will go under debt counseling, and then that specific amount that needs to be paid as a lump sum every month will be paid to the debt counselor. The debt counselor has a management fee of the specific amount that he receives monthly into his account, and the debt counselor will then distribute the funds accordingly to all the relevant parties. There's also a process that can be followed where a specific debtor can go under what we call administration. Some of you might have some knowledge about an application to go under administration. And there's mainly 3 of these different routes you can follow: going under administration, going under debt review, or sequestrating yourself. The problem with going under administration, if my memory serves, then this is where you only have debt that is less than 50,000 rands in total value, and there's no immovable property where the debt, you don't owe any debt in terms of an immovable property. If you go under administration, the amounts will only be distributed to the relevant parties every second month, whereas with a debt review that will be on a month-to-month basis. And then in court, when you appear in court, a magistrate might have queries on the debt review, might be postponed for the queries to be satisfied, and thereafter only grant the order. The problem that we do have in practice is twofold. Number one, for the period in which the application is still pending at court, you may not continue with your litigation against the specific debtor. So what debtors will see is that a lot of attorneys are hunting them for arrear amounts, and then they would eventually go and see a debt counsellor. As soon as the application is launched, then you can continue with litigation pending the finalization of the application to go under debt review. Another issue that we see quite a lot with clients is that they say that someone owes them but has gone under debt review a year or two ago, but their claim was never included. You must remember that the debtor goes to the debt counsellor, and he or she needs to basically lay everything in front of the debt counsellor, and it does happen that they do not always include all the claims. You may then launch an application. What I normally just try and do first is to discuss, same with the debt counsellor, to include your claim in that specific debt review. But it does happen that a debt counsellor refuses, and then you may approach the court and launch an application to have your claim included in the debt review. I want us to just read these first two paragraphs. This part of the NCA does not apply to credit agreement in respect of which the consumer is a juristic person, which means it's only for private people. A company cannot go into a company cannot go under debt review. In today's day and age, we see that companies go under business rescue. Then the NCA requires that a credit provider, this is normally your bank, would carry out a financial assessment to determine the extent or amount of credit that a credit applicant can afford prior to entering into a credit agreement with the applicant. The affordability assessment that a credit provider must undertake is contained in the section of the NCA set out below. So this means that there's a duty upon both parties, both the credit provider and on the specific applicant applying for the credit. So let's have a look at section 79. This basically just says that a consumer is over indebted if he or she cannot reasonably satisfy all the obligations under a credit agreement timeously with regard to the financial means, prospects, etc. I want us to first can have a look at section 86. Section 86 is the portion that I just now discussed regarding a debt counsellor, and it reads as follows. A consumer may apply to a debt counsellor to have the consumer declared over indebted, because this is exactly what your debt counsellor will do. He needs to file a certificate confirming that the debtor is in fact over indebted. Such an application may not be made if at the time of the application the credit provider under that credit agreement had proceeded to take the steps in terms of section 189 to inform that agreement. Now, this is important with the bullet points. A debt counsellor must do the following. Must determine whether or not the consumer is in fact over indebted, and if the consumer seeks a declaration of reckless credit. Now I need to pause here. I've had one or two fights with debt counsellors, and my apologies if anyone listening in is a debt counsellor. I've had one or two fights with debt counsellors in the past wherein a debt counsellor refrained from declaring a specific transaction as reckless credit, due to the fact that if a debt counsellor did go and declare that specific transaction as reckless credit, then that would mean that the debtor would not be over indebted anymore. If you, as an example, this is the discussion I had yesterday afternoon. An attorney phoned me, and we had a discussion about my client that entered into an agreement during 2018. My client was subsequently sequestrated during 2015 and was never rehabilitated. So my client was not supposed to be able to enter into the specific agreement. So the agreement was entered into 2018, which means that the financial institution failed to do their due diligence to make sure that this specific client did comply and did have the financial means to make payment of the credit agreement. So the debt counselor that does see that there is reckless credit and fails to report this is negligent. A debt counselor must report reckless credit. And it continues to say whether or not any of the consumer's credit agreements appear to be reckless. You will see in some of these sections, the court also has a discretion if the court is not satisfied with the findings of the debt counselor, then the court may direct the debtor to seek a third opinion or a second opinion and to hand them up to court. The debt counselor reasonably concludes the following: that the consumer is not over-indebted, the debt counselor must reject the application, or if the consumer is not over-indebted but is nevertheless experiencing or likely to experience difficulty satisfying his or her obligations under the credit agreement on time, then there should not be an application to go under debt review. This is the following that the debt counselor will do: may recommend the following: that the respective credit providers voluntarily consider and agree on a plan of debt rearrangement. This is where the term will be extended and or the interest rate will be lowered to bring the monthly installment more in line with what the debtor will be able to afford. Or the consumer is over-indebted, the debt counselor may issue a proposal recommending that the magistrate's court either or both of the following orders: to declare one or more of the agreements as reckless credit if the debt counselor has concluded that those agreements appear to be reckless, and that one or more of the consumer's obligations be rearranged. And this is how it is rearranged: by extending the period of time, which I already mentioned, postponing the dates on which payments are due, or extending the period of the agreement and postponing the dates on which payment are due, and or recalculating the consumer's obligation. I've seen some of these examples where someone earns a salary of approximately 30,000 rands, but his debt is about 29,000 rands. It's just unreasonable for such a person to be able to survive monthly, still pay all their debt, where debt will be restructured down to about 15 or 18,000 rands a month, which puts a lot more money back into the debtor's pocket at the end of the month. I want to pause here and just quickly mention there is one specific financial institution. I'm not going to mention any names, but they saw a gap and duly took the gap when it came down to debt reviews. So what they said was, when you bring an application to go on a debt review, you will, as a debtor, after the debt review is granted, you will have more funds available, more money in your pocket. So when the debt counselors phoned the specific financial institution, the financial institution would go and appoint attorneys and say to the attorneys, we reject any claims from the debt counselor. The reason for this is, if the debt counselor said, listen, we will pay you 1,000 rands a month over a longer time frame, the specific bank would say, no, we don't want this. We want 2,000 rands per month. And the reason why they do this is because after the restructuring, the debtor will have much more money in his back pocket, which means the debtor is still desperate to go under debt counseling. And due to the fact that he's going to save on a lot of other avenues, why don't we just pay the 2,000 rands per month? Which means that that specific bank did this on hundreds, if not thousands, of debt reviews, and now receive a a larger monthly payment in terms of their debt. And if you multiply that by thousands of debt reviews, that means that they getting a lot more of their debt in. Section 87. If a debt counsellor makes a proposal to the magistrate's court, the court must conduct a hearing. Now, this hearing is what we call motion court proceedings, which means that, and this hearing is not like in a trial where the magistrate will ask witnesses to come and testify and questioning. This hearing basically means that the magistrate needs to consider the papers in terms of the application, and then having regard to the proposals and information before it and the consumer's financial means, the court may do the following: reject the recommendations of the debt counsellor, make an order rearranging the consumer's obligation, or make both of the above orders. Right, before we continue with surrendering of and debt enforcement, I want to have a look at some of the other sections above. And before we do that, I need to mention that there is a duty upon both parties, such as the financial institution and the consumer. Both parties need to act truthfully and do their due diligence. In terms of legislation, the financial institutions will be governed by legislation, and they need to continue up to a certain point to make sure that the specific application pending before them will comply, and that the debtor does have the financial prospective means to make payment. However, if the debtor does not declare his or her financial past truthfully, then a court may make a determination that even though the debtor is not in a position to make payment, that specific funds that was allocated to this debtor will not be regarded as reckless credit due to the debtor being untruthful, and the specific amount will be enforceable by the financial institution. So section 83, if a court declares that a credit agreement is reckless, the court may do the following: set aside all or a part of the consumer's rights and obligation under that agreement, may suspend the force and effect of that specific credit agreement, may suspend the force, that's just a copy, or restructure the consumer's obligation. Section 84, during the period that the force and effect of a credit agreement is suspended, the consumer is not required to make any payment required. No interest, fee, or other charge under the agreement may be charged, and the credit provider's rights under the agreements are unenforceable. So this will be a great tool in terms of Section 84 for the specific applicant to use if he wants to declare a specific amount as reckless credit. Because if it is declared as reckless credit, then the court may make a call to say that there needs to be no payment of that amount, and it will also not be enforceable. Section 85, very important. When a credit agreement is being considered, if it is alleged that the consumer under a credit agreement is over-indebted, the court may refer the matter directly to a debt counsellor with a request that the debt counsellor evaluate the consumer circumstances and make a recommendation to the court. I've seen this happening in Section 65 court as well, where it becomes apparent that we have now obtained judgment. After obtaining judgment, we continued with writ. We are at Section 65 court now, and when we do the financial assessment, the court actually sees that the debtor doesn't have any funds to pay and is in actual fact over-indebted. The court may then make a determination in terms of Section 85 of the National Credit Act that the specific debtor go and seek a debt counsellor and the opinion of a debt counsellor. Right, I think we will just take a 5 to 6 minute break. I'm just going to get some of the questions ready, and then we'll deal with some of the questions, and then I want to continue with the surrender and debt enforcement. All right, everyone, I think let's continue and push through. We only have a couple of minutes left. I managed to have a look at the questions received. Thank you for all the questions throughout the 2 days. I really appreciate that, and I hope that some of the answers will just push you in a direction. After the lecture, I will also just give my details. If you also need my details or want to discuss something in more detail, you are very welcome to also just give Merlin a call or send her a mail, and I'm sure she will just forward your query and or details to myself, and we can have a more informed discussion about a specific topic. But before I look at the questions, what I think I'm going to do is I'm first going to just finish with the National Credit Act portion, and not jump around too much. And then we'll have a look at a few questions, and then that is it. I'll ask Mullen whether there's another question or two that might come in the next couple of minutes. But time has gone by really quickly. But let's continue. Surrender and debt enforcement. In terms of certain sections, especially section 127, and if I scroll down, in terms of section 129, this is the National Credit Act, but especially 130, section 130, you may surrender, and then the surrendering of goods. I want to stop here. Section 127. Now, it reads as follows, that a consumer under an installment agreement, now we all have our cell phones and laptops and so on that we might be paying off on a monthly basis, so have that in the back of your mind. A consumer under an installment agreement or a secured loan or lease may give written notice to the credit provider to terminate the agreement. If the goods are in the credit provider's possession, the consumer may require the credit provider to sell the goods, or may return the goods to the credit provider's place of business within 5 days after the date of the notice, or within such other period, or at such other place as may be agreed. So 2 scenarios that will happen here is that your debtor is at the point of being over indebted, and he sees that he cannot pay the cell phone anymore. So at this stage, he might be up to date with all his payments. He may surrender the goods in terms of section 127 and give the cell phone back to the Vodacom, MTN, Cell C, and then ask them to sell the property. So if he has a couple of months left on the contract, obviously they will bill him for the remainder of the contract, but that specific cell phone will still have a financial value. Now, if you are up to date with your specific monthly payments, then the service provider must give you an estimated amount of what this device will be worth, sold on a second hand at auction. And if you're up to date with your payments, you may then decline that the property be sold, and this must then be returned to yourself. If you, however, are behind with your monthly installments, a couple of months behind, and you then surrender the goods in terms of section 127, the provider will still give you an estimated value of the goods, but you may not reject same and then request possession to be restored of the goods, and there the credit provider will in actual fact have the right to retain possession and to sell the property at auction. So there's a lot of debt collection to be done, not just for banking institutions and insurance companies, but also for credit providers such as your telecommunication industries. Now, in terms of section 127, then within 10 business days after receiving a notice to sell or after receiving goods tendered, a credit provider must give the consumer written notice setting out the estimated value of the goods, what I explained just now. Another good example of this will be a motor vehicle. If you cannot pay your motor vehicle anymore, it's still worth something, you may hand it back in terms of section 127. But if you are behind with your installments, chances are that you won't be able to get the vehicle back. It will be sold. Then within 10 days after this estimated value, then within 10 days after receiving the notice, the consumer may unconditionally withdraw the notice to terminate the agreement, which means that you want to resume possession of any of the goods. Now, if the consumer responds by withdrawing, the credit provider must return the goods to the consumer unless the consumer is in default. Exactly what I've explained just now. If the consumer does not respond, the credit provider must sell the goods as soon as practicable for the best price reasonably obtainable. This is normally at auction. After selling of the goods, the bullet points will then explain to us, after the selling of the goods at auction, the credit provider must then supply you with a written notice, almost like a distribution account, setting out the value, the gross amount that was received at sale, the proceeds of the sale deducted by the capital debt, etc. And if there is a shortfall, what amount will remain due, and if there isn't any shortfall, the amount credited or debited then to the consumer account. So this is surrendering in terms of section 127. I want us to also have a look at section 130, debt procedures in court. In terms of section 130 of the NCA, a credit provider may approach the court for an order to enforce a credit agreement only if the consumer is and has been in default under the credit agreement for at least 20 business days. So this is where the section 129 letter of demand will afford the debtor 20 days to remedy the breach. Not like your normal letter of demand, your section 56 letter of demand, wherein you will afford your debtor 7, 10 days or whatever your specific contract might recommend. Then it continues to say the consumer is and has been in default under that credit agreement for at least 20 business days, and at least 10 business days have passed since the credit provider delivered the notice referred to above, or the notice after an application for debt review. And continues with the last two bullet points to say that the consumer has not responded to the first mentioned notice, or has responded by rejecting the credit provider's proposals. And in the case of an installment agreement, secured loan or lease, the consumer has not surrendered the relevant property in terms of section 127. So section 130 in essence explains to us what happens with our section 129 letter of demand, and thereafter, if the debtor did not comply or make payment proposals, then you will in fact continue with service of a summons. Repossession of goods, section 131 specifically deals with the repossession of goods, and I just want to pause here and discuss the repossession of motor vehicles. It is so, and it is apparent that that the financial institutions does have people on the ground that would go to specific debtors that's behind with especially motor vehicles, and to repossess the motor vehicle. So what they call them runners. What these runners will do is that they will go to the specific debtor's property and they will ask the debtor to sign specific documents. So what they in actual fact are doing is debt collection for the financial institution. The reason being, the financial institution does not want to necessarily spend in terms of legal fees in launching applications at court to get a court order to repossess a vehicle. The documents that these guys will present to your client, if you sit yourself in a position where you act on behalf of the debtor now, these documents will specifically mention that your client surrendered the goods in terms of section 127. So it's happened on a number of occasions where clients have phoned me and said there's people there enforcing them to sign documents, and your advice will just be do not sign the documents, because as soon as they sign the documents, the vehicle will be repossessed, and in actual fact your client will sign a section 127 repossession, and the vehicle will be taken by those people, and it will be sold at auction. Dispute settlement other than debt enforcement. This is quite important due to the fact that the National Credit Act does not just govern specific transactions dealing at arm's length between parties in the Republic. In terms of a court as we know it, as a magistrate's court or a small claims court or high court, but there's also specific tribunals. You guys can go and read the specific portion and a national credit regulator that you'll see there that will look at the interest variation provided by the Act. So there is different tribunals and regulators that's also governed by the Act, dispute resolution centers, etc. And I want us to have a look at the credit policy. But in a nutshell, what the credit policy boils down to is that the National Credit Act's big aim is to try and what they actually call in the Act to prevent what they call predatory practices. So what happened years ago was that especially loan sharks, you won't see them as prevalent anymore, although they are still there. Loan sharks would borrow funds to a specific debtor, and then this was not regulated by legislation, and now the enforcement of loan sharks in terms of legislation will not take place, because in order to afford debt to a specific applicant by a financial institution, the loan shark will need to be registered as a credit provider in terms of the Act. If he or she cannot provide the certificate that this financial institution is a national credit provider, then default judgment will not be granted. So the Act, I think, did succeed with its purpose in terms thereof, where it tries to mitigate predatory practices, and now you need to be registered as a credit provider. And this is also one of the questions that we received, and I think we can move on and discuss a few of the questions. You can go and have a read of the remainder of this handout and the specific sections that we dealt with. The questions that we received, some of the questions as follows. It says, where summons was issued regarding outstanding rent and the debtor starts making payment and then defaults, can you add the rent due after the amount claimed or the summons on the summons, or will you have to institute a separate action? So what we need to understand with the rental market, back to the rental market, is that each and every month is what we call its own cause of action. So you can in actual fact issue a summons for each and every month. Obviously that will just incur unnecessary costs. So when a client would come to you, you would advise the client to issue one summons for the 4, 5, 6 months that is currently owing. But it does take time to go through court. So in that time, the debtor starts making payment but defaults again. You will need to reissue a specific summons for those specific months, because in your summons, in your particulars of claim, you will surely say that the full claim amount is 50,000 rands, consisting of the following: rental for January 10,000, rental for February 10,000. So if a certain portion of this was paid, then you cannot just go and add additional months rental to that specific summons. You will need to reissue for those specific months. Question: what happens if a company goes into business rescue? And I think it is a very prevalent question, very good question, as this happens on a daily basis. When a company goes into business rescue, the most important for you as a debt collection attorney is to know that you can no longer continue with litigation against that company. So in terms of the Act, the litigation will be pending the finalization of the business rescue plan to be adopted and the whole application to go under business rescue. Now, in short, business rescue is dealt with by a business rescue practitioner, and a business rescue practitioner must draft a business plan to be adopted by the creditors at a majority vote, and then that business plan should be executed, and if it fails, then that company is supposed to go under automatic liquidation after 3 months. Now, what I've seen happen, and we've had to deal with this once or twice before, is that a company is over indebted in the fact that it cannot pay its salaries, it cannot pay all its expenses, and then the company would go under debt, not debt review, the company would go under business rescue whilst you're busy or in the middle of litigation. But what then happens is that all the creditors need to participate in the business rescue process. But many times it happens that the business rescue practitioner does not push the process, and everything stalls. So we've approached the High Court successfully on a number of occasions with an application asking the court to set aside the business rescue process in order for the creditors to continue to pursue the company with litigation. What's also happened before, if a company goes under business rescue, please continue to place a lot of pressure upon the business rescue practitioner. Ask them for progress. When will the creditors' meetings be? When will the business plan be adopted, etc.? If you start threatening, if the business rescue practitioner does not continue with the process, and if you start threatening with legal action to set aside the business rescue application, more often than not, they will start to engage you in an effort to try and settle the matter with your client. Next question, can debt be declared as reckless if it was granted by a financial institution for a second property? Yes, certainly. Remember, when you apply for finance, the financial institution needs to have a look at what is your current financial position, whether you have 10 properties or 2 properties. They must have regard to your current financial position, and if you're not in a financial space where you are supposed to receive the credit for your second property and they still afford you the credit, then yes, it could be seen as reckless credit. Another question, how do you rescind judgment after the sheriff has attached goods and 20 days has elapsed after the default judgment? So just back to a bit of litigation, you will be in a position to still continue with a rescission of judgment. Although the rules, and this is in terms of Rule 49 combined with Section 36, Rule 49 combined with Section 36. Now the rule specifically states that the debtor needs to apply for the rescission of judgment within 20 days of becoming aware of the judgment being granted against him or her. If 20 days has, however, lapsed, you can still launch your application for rescission, but you need to ask the court to grant condonation of the late filing. So when you bring your application at court, you will ask the court the following in your notice of motion. 1, that condonation be granted for the late filing of the specific application. 2, that the judgment be rescinded. 3, costs if opposed for further alternative relief. And in your affidavit, you will need to explain to the court why you only want to rescind the judgment after 54 days, for instance. You need to explain to the court why you are late and that you have good prospects. A question here, can the court set aside the agreement if the credit provider do not follow correct procedures, like starting with the letter of demand? So can the court set aside the agreement if the credit provider do not follow correct procedures like starting with the letter of demand. It seems to me like the question relates to litigation, where litigation has already started, and um, the specific person would like to have the amount set aside due to the fact that a letter of demand was not sent. Well, firstly, you need to make sure that the letter of demand was sent or not, because many times when you enter into these agreements, they ask for a domicilium address. The specific person might not stay at that address anymore, or the letter of demand was only sent by a registered post and it was never received. So make sure that it was sent or not. But if you're busy with action procedure and summons was issued, then you're not dealing with Section 86, where you're going to ask the court to set aside reckless credit. All right, this question, when a debtor is under debt review, must payments of the outstanding amount be made to the creditor directly or to his attorney? So remember I said that the specific person going under debt review will no longer entertain the 10 companies that he or she owes money. The specific person going under debt review will make payment of the lump sum amount directly into the debt counselor's account. The debt counselor then goes and distributes these amounts directly to the specific creditor, and the debt counselor will either pay it directly to the creditor or to his or her attorney. If I was the debt counselor, I would rather request that the funds be paid directly to the creditor, due to the fact if it's been paid to the attorney and to the attorney's trust account, then the attorney will take collection commission on this amount, meaning that it will take longer to pay all the debt in terms of the granted order. All right, guys, it doesn't seem like we have any further questions. If you have any further questions, please feel free to contact Merlin. Send her a mail. You may ask her for my details, and then what we can do is I'll just answer. I think let's just wait a few seconds. Merlin just informed me now that there is a question or two that just came in now. So just give me 30 seconds. I'll be back just now. All right, let's quickly continue. We have time for one or two more quick questions. I see there is a question here. What must we do if the agreement we have between the debtor and our client is a copy and the court wants the original? So this happens very regularly, that original documents, it's not available or it's impossible to obtain it. Then what you do is you draft a lost document affidavit and you explain to the court why you only have the copy and not originals. It happens quite regularly that, for instance, we had a question earlier that a warrant of execution is only a copy and the sheriff needs an original. So if you want default judgment granted, we mentioned that you need to, as far as possible, supply original documents. If it is not possible, you will do a lost document affidavit in terms of Rule 12 sub 6, if that is in the magistrate's court. Another question: what must we do if the agreement we have between the debtor and our client is a copy and the court wants, sorry, that's just a copy of the same question. With regards to reckless credit for second property, if granted, what could then happen with the property? Right, so the property, it seems like the bond for this property was successful, and I assume it was purchased as well, and it was paid off, hopefully for a couple of months or years, and now suddenly there is financial difficulties. If it specifically shows that that bond amount was reckless credit, then you could go back to that specific contract between the provider and the consumer and ask. What I would do is I would go and ask a specific debt counselor or two to write an opinion on this, and to provide you with an opinion whether that could be seen as reckless credit based on the time when the credit was afforded. So if on the time when the credit was supplied, the specific consumer had the funds to make payment thereof, but subsequently lost a job, lost contracts, etc., that will have a severe implication on whether it will be regarded as reckless credit. And you don't necessarily need to go to court with the Section 86. You could just bring a normal application in a normal sense, whether it be to the Maj Court or High Court, and ask the court to, in terms of the Act, declare that specific bond, if it is a bond, as a reckless credit. Last question. After judgment was granted, the debtor pays the full outstanding amount together with costs. What is my duty as debt collector after that? After judgment was granted, the debtor pays the full outstanding amount with costs. What is my duty as debt collector after that? Well, your duty is to obviously try and get your costs from your client. As the attorney, you need to be paid as well. So if it was, the cost was only the taxed costs, you will then continue to, I assume, to close your file. You got your funds in for your client. What does, however, happen in practice quite a lot is that the debtor will say, but judgment was granted, so who's going to rescind the judgment? So the onus is not on the debt collector to rescind the judgment. That is an application in terms of Rule 49 and Section 36, which the debtor, him or herself, needs to launch. So what I would do with this specific person is to refer them to an attorney to launch an application to have the amount or the judgment rescinded, rather. And what you could do from your side before closing your file is to maybe supply the debtor with a paid, what we call a paid up letter, just to confirm that the amount plus cost and interest has been paid, and that your client will not have any objection to the judgment being rescinded. But that's an application the debtor needs to launch at their own costs. All right, everyone, thank you very much for your time, and thank you for your questions. I do hope that it did add value. And if there's any questions, please pose them to Merlin, and Merlin will will send him through to me if you want to get in touch with me. She'll have all my details. And again, thank you very much for your time. Enjoy your day and week.